So often when people ask me, what do I need to win a particular type of employment case, I'm going to give them the standard lawyer answer, which is it depends, right? But with retaliation cases, I have a very different answer because with retaliation cases, there has to be some protected conduct by the employee. So the employee's complaining about, disclosing, objecting to, refusing to participate in conduct that they believe is illegal, or they're complaining about discrimination or workplace retaliation. So that has to happen first. And then there has to be some retaliation against the employee. So retaliation takes the form of some action that is unfavorable to the employee. And in lawyer words, we call that adverse action. And when you can establish the chronology like that, there's some action by the employee, protected action, so complaining about discrimination or harassment or retaliation, followed by an adverse action, this retaliation that comes after it. That's how you establish a chronology for a successful retaliation claim. The closer in time the protected conduct, the complaining about discrimination, retaliation, or harassment, to the adverse action, the retaliatory action, the closer those two are, often the better, because it really shows that that action was taken in retaliation for that protected conduct that the employee engaged in. And when we look at retaliation cases, we find generally that sometimes there are some members of society, so meaning jurors, right, that don't necessarily believe that discrimination still exists in workplaces, or don't believe that it goes on without being remedied or fixed. However, jurors generally understand that if an employee says to an employer, hey, you can't do that, or what you're doing is wrong, that employers don't like that, and they're going to come after that employee. And so having that chronology is by far the most important thing to establishing a successful law against discrimination retaliation case.